A patrol car pulls up behind a vehicle on a quiet road. The red and blue lights begin to flash, reflecting off the asphalt in the back window of the car ahead. The driver pulls over, heart beating a little faster, mind racing through 100 questions at once. What did I do wrong? Is this just a warning? And then another question, one that many people wonder in moments like this. Can the police search my car? It's a moment that plays out thousands of times every day across the United States. A simple traffic stop can suddenly turn into something more serious. An officer may ask questions. They may ask to look inside the vehicle, and sometimes they begin searching. But here's the question that many people misunderstand. When are police legally allowed to search something without your permission? Think about that for a moment. If an officer stopped you today, would you know what they are legally allowed to search without asking you first? Would you know when the Constitution protects you and when the law gives officers the authority to search anyway? Share your thoughts in the comments as we explore one of the most important principles in American constitutional law, the limits of police searches. To understand this issue, we have to begin with one of the most powerful protections written into the United States Constitution, the Fourth Amendment. Adopted as part of the Bill of Rights in 1791, the Fourth Amendment was created to protect people from unreasonable searches and seizures by the government. The framers of the Constitution had lived under British colonial rule, where officials sometimes conducted broad searches without clear justification. They wanted the new American government to operate differently. The amendment states that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. It also establishes that warrants must be based on probable cause and must specifically describe what is being searched. On its face, the amendment seems simple. Police generally need a warrant issued by a judge before they can search private property. But in real life, law enforcement operates in fast-moving situations where waiting for a warrant is not always possible. Over the past 2 centuries, courts have recognized certain exceptions to the warrant requirement. These exceptions define situations where officers are legally allowed to conduct a search without first obtaining permission from a judge. Understanding those exceptions is key to understanding what police can legally search without your consent. One of the most widely recognized exceptions involves something known as probable cause combined with mobility. In simple terms, if officers have probable cause to believe that a vehicle contains evidence of a crime, they may be allowed to search it without a warrant. This principle is often called the automobile exception. The logic behind this rule dates back to the early 20th century. Unlike a home or building, a vehicle can quickly move away from a location. If officers were required to pause and obtain a warrant every time they suspected evidence inside a vehicle, the evidence might disappear before they returned. As a result, courts have allowed officers to search vehicles without warrants in certain situations where probable cause exists. However, that does not mean officers can search any vehicle whenever they want. The key requirement is probable cause. Probable cause means that officers must have specific facts that would lead a reasonable person to believe evidence of a crime is present. For example, if officers smell the odor of illegal substances coming from a vehicle, courts have often ruled that this can establish probable cause. Similarly, if officers see illegal items in plain view through a window, that observation can justify a search. The concept of plain view is another important legal principle. If an officer is lawfully present in a place and clearly sees evidence of a crime without conducting a search, that evidence may be seized. For instance, if an officer approaches a car during a traffic stop and notices illegal items sitting openly on the passenger seat, the officer does not need a warrant to take action. The reasoning is that the officer did not search for the item. It was already visible. Another situation where police may conduct a search without permission involves officer safety. During a lawful stop, officers are allowed to perform a limited protective search for weapons if they reasonably believe their safety could be at risk. This type of search is often called a frisk. The concept was clarified in a landmark Supreme Court case called Terry v. Ohio. In that case, the court ruled that officers may conduct a limited pat-down of a person's outer clothing if they have reasonable suspicion that the person may be armed and dangerous. This is not a full search. It is intended only to check for weapons that could pose a threat. The idea is to balance public safety with constitutional protections. Another common exception involves something known as a search incident to arrest. When police make a lawful arrest, they are allowed to search the person being arrested and the area within their immediate reach. This rule exists to prevent suspects from accessing weapons or destroying evidence. For example, if someone is arrested during a traffic stop, officers may search their pockets and nearby areas for safety and evidence. However, the exact scope of these searches has evolved over time through court decisions. Another important exception involves consent. If a person voluntarily gives officers permission to search, then a warrant is not required. Consent searches are common during traffic stops. An officer might ask something like, "Do you mind if I take a look inside your vehicle?" If the driver says yes, the search becomes legally permissible. However, consent must be voluntary. Courts have repeatedly ruled that consent cannot be obtained through force or coercion. But this raises an interesting question. How often do people truly feel free to say no during an encounter with police? Legal scholars and courts have debated this issue for years. Another area where searches can occur without permission involves something known as exigent circumstances. This refers to emergency situations where waiting for a warrant could lead to immediate danger or the destruction of evidence. For example, if officers hear someone inside a building calling for help, they may enter without a warrant. Similarly, if officers believe evidence is about to be destroyed, they may act quickly to prevent it. These situations are relatively rare, but courts recognize that emergencies sometimes require immediate action. Technology has also introduced new legal questions about searches. In the modern world, many of our personal records exist digitally on phones and computers. For years, courts debated whether police could search a cell phone without a warrant after an arrest. That question reached the Supreme Court in the case of Riley versus California. In that decision, the court ruled that police generally must obtain a warrant before searching the digital contents of a cell phone. The justices recognized that smartphones contain vast amounts of personal information. Because of this, digital searches require stronger constitutional protections. The ruling demonstrated how constitutional law continues evolving as technology changes. Throughout American legal history, courts have tried to strike a balance between two important goals: protecting individual privacy and allowing law enforcement to perform their duties effectively. Neither goal exists in isolation. If laws were so strict that officers could never act quickly, public safety could be compromised. But if officers had unlimited search powers, individual freedoms could be threatened. The Fourth Amendment sits at the center of this balance. Every year, courts across the country hear cases that test where the boundaries should lie, and each decision gradually shapes how search laws are applied in real life. For everyday citizens, the most important thing to understand is that the legality of a search depends on the circumstances. Was there probable cause? Was the officer lawfully present? Did an emergency exist? Was the search connected to an arrest? Each of these factors can change how courts evaluate a situation. That's why two searches that appear similar on the surface can be treated very differently in court. Context matters. The law often focuses not only on what happened, but also on why it happened and what officers knew at the time. Understanding these principles can make encounters with law enforcement less confusing. It helps explain why officers sometimes ask for permission before searching, and why in other situations they may proceed without asking at all. At its core, the Fourth Amendment reflects a principle that has guided American law for more than 200 years. The government must justify its power to search. That justification may come from a warrant issued by a judge, or from one of the carefully defined exceptions recognized by courts. But it cannot be arbitrary. The boundaries exist to protect both public safety and individual liberty. As society changes, courts will continue refining these boundaries. New technologies, new investigative methods, and new legal challenges will continue shaping how search laws are interpreted, and every new case adds another chapter to the long story of constitutional rights. So the next time you see flashing lights in your rearview mirror or hear about a search in the news, remember that behind that moment lies a long legal history. A history shaped by court decisions, constitutional principles, and the ongoing effort to balance authority and freedom. And now we'd like to hear your perspective. Do you think current search laws strike the right balance between privacy and law enforcement powers? Or should the rules be stricter when it comes to searches without permission? Share your thoughts in the comments and join the conversation about one of the most important protections in constitutional law.